My name is Amanda Rocha. I am an estate planning and probate attorney in California, and today I'm going to walk through practical and legal issues as far as your daughter or son-in-law inheriting from you. Before I get into that, I want to give you my contact information. You can contact me on my website at www.amandarocalaw.com. There you can schedule a call directly on my calendar. We could talk about whatever it is that you are concerned with regard to estate planning and probate in California. You can follow along on my social media. I'm at Amanda Rocha Law. There you can send me a message or comment on one of my videos, or comment down below if this platform allows you to do that. So let's get into it. What about your daughter-in-law? What about your son-in-law? If you pass away, are they going to inherit from you? So there are a couple ways to inherit from someone. One is if you don't have an estate plan at all, in which case your heirs are going to be usually your spouse and children, and if you don't have them, there's a whole list of people who will get them, who will get your inheritance. Your daughter-in-law and son-in-law are not on that list. We can go into that in greater detail on another episode of this. As far as inheriting with an estate plan, when you list your child as your beneficiary, regardless of whether they are married, it does not matter what state they live in, it does not matter how long they've been married, inheritance is separate property and is not community property. So if they receive $5 or $500 million from you, as long as they keep that property in a separate account or do not commingle it with property that they have with their spouse, then their spouse does not have a right to that property immediately. Practically speaking, generally when you are married, your spouse has input on what you do and you are trying to be cohesive with them. Unless you have a very specific reason why you would want to keep funds, let's say it's money, separate, then usually it's going to be commingled. And once it's commingled, then it's both of theirs, especially at least in California when you're in a community property state. As far as real property goes, let's say you left a house to your son, and you are worried that your daughter-in-law's name will be on the title. The only way her name will get on the title is if your son puts her name on the title. It will not immediately go to her. However, even if her name is not on the title, if she is using some of her money, or if your son is using some of the community property money to pay for the mortgage or pay for upgrades or anything having to do with that property, she will have some sort of claim to part of it, depending on how much was spent and for what and whether it was paid back. So you can be sure not to include your daughter or son-in-law in your estate plan if you do not want to specifically give them anything, but you cannot force your child to not share their inheritance with their spouse, although some people prefer that. Another route that you can go with is you may leave property, money, whatever it is, to your children in a trust and have the trustee keep complete discretion as to what they're going to do with that. So you can say, I want you to provide for my son throughout his lifetime based on needs that you determine. So the trustee then, after you pass away, will have to determine how much, if anything, and when, if ever, to gift inheritance portions to your son. Still, that does not mean that your daughter-in-law or son-in-law aren't going to be able to manipulate those funds once they become part of that person's account. But a trustee could pay for things directly without ever giving a beneficiary access. So if that trustee is going to pay for a medical bill or pay directly for education or something like that, they can do that, and then the spouse won't ever be able to reach it. So there are little things we can do to try and craft how much, if anything, goes to the in-law, but practically speaking, they will most likely have some sort of asset entanglement, or they'll have some way of helping manipulate what happens to that money or property after you've passed away. as long as your child is okay with it. So if you have questions about this, please comment down below. Go to my website, www.amandarochala.com. You can schedule a call with me or follow along on my social media and send me a message that way. I'm at Amanda Rocha Law. Thank you.